Welcome to another edition of Florida Appeals Journal. It's fall 2024. We finished with the summer. So now we get to get into some exciting issues facing litigators this year, the last part of it in 2024. Today, I want us to talk about a very interesting issue, and it's not one you run across every day. The question is, to what extent can you challenge a discovery order on appeal? Most discovery orders, and discovery, all attorneys know this, if you're not an attorney, it deals with production of evidence, potential evidence, documents you have to support or defend your case. All right. But you're going through pre-trial, you haven't got to trial yet, and there are requests being made of you to produce documents, or maybe you're making the request. If you get an order from the trial judge that you don't agree with, your order to produce something that you don't think you should produce, or the way you're being ordered to produce it, there's a problem with that. What can you do about it? After all, the trial judge has considerable discretion over these type of pretrial issues. Most of the time, you can't do anything about it, especially with discovery. It's not automatically an appealable order. It's not an appealable non-final order. But there are certain situations where you can appeal, or rather file an extraordinary writ. And that writ is usually petitions for writ of certiorari. And we have a video on petitions for cert in general. But remember the standard for your petitions for cert. The order has to be a departure from the essential requirements of law. It can be remedied by an appeal from the final judgment of the case. And it has to bring about irreparable harm. So you have a discovery order. Typical is a situation, you have a situation where you've been ordered, mere corporation, you've been ordered to disclose and produce either as confidential documents or trade secret. There could also be attorney-client documents, documents that could be subject to many privileges. That's an order, you want to preserve and make your arguments to the trial court. But if they're ordered to produce something that, if you produce it, you can't remedy it on appeal, it's going to cause you harm, and hey, it is something privileged, then you can appeal it by way of an extraordinary writ, and you would do a petition for certiorari. What I want to talk about specifically today, though, and that's not talked about very often, is the method of production. To what extent can the trial court require you to produce it, let's say produce documents in a certain way? I mean, you may have the other side complain that, well, you can't just give me a bunch of documents. You've got to sort them out and categorize them to support each claim. And on one hand, I mean, a layperson would think, well, maybe that makes sense. But when you look closer at it, it's not a good thing, right? Because if you have a broad request like that, especially if it's a broad request, you're on the other side, in essence, getting some of your mental impressions and really invading what's called a work product privilege. So you want to, when you are looking at whether you're drafting or you're looking at requests from the other side, you want to be careful and look for that. Don't just be in a rush to produce it. Make your objections. You may want to move for protective order. You've got to read those requests very carefully. If they say there's a request, I want you to produce all documents, any discussions that have any discussions or relate in any way to the claims that you've made, definitely overbroad. But you got to break it down and say, wait a minute, I need a motion for protective order here, because you're asking also for privileged documents. But you're going beyond that too. If you're asking, well, I want it categorized and match it up, say, to the allegations you made in your complaint, or match it up to, if you're on the defense, to your affirmative defenses and defenses. Well, it's very interesting because the courts have said, can't do that. You need to be aware, and I'm sure many of you are, aware of the Florida Rule of Civil Procedure, 1.350B. Okay. Now, that's a great rule. And when we're talking about production of documents, and let's say, we're beyond the privilege and their non-work product, that specifically requires the producing party to produce the requested records, quote, as they are kept in the usual course of business, okay, or identify the documents produced to correspond with, uh, I guess, the request. Now, the courts have held that because the rule actually gives you a choice, okay, you have an option, they have held it as error, reversible error, to order the responding party to produce the documents to correspond with the categories of the request. That's very interesting. And the Evangelos case, Evangelos v. Daschel, 553 Southern 2nd 245, the third DCA case. In that case, the plaintiff served a request for production seeking all of the business records of two defunct corporations for an 8-year period. And the defendant produced 30 boxes of documents in the storage room where they were maintained. The court held that by producing the documents as they were kept in the usual course of business, they had complied with Rule 1.350B. So they didn't have to break it down. And if you have a party that's insisting on producing it, and I want to emphasize, read the rule carefully too, because that really dictates what you can and can't do. But if you have a party that goes to the court and they're demanding that it be produced in a certain way, and they have reasons, who's going to be responsible for the cost of preparing those documents in order to comply with the parameters requested by the other party? And they could be significant if you have, thousands and thousands of documents, if they need to be put in a certain order, if they need to be gathered. If there's a reason, the court can agree with the party making that request that, okay, we need to produce them in a certain way, or we need to produce them off premises. You're going to have to send these over to the other side. The court can make the requesting party responsible for payment, and not just copies, of course, but the expense of having a paralegal or even the attorney compile those documents, gather those documents. So the cases I want to give you, there's a case, Schering, Schering v. Thornton, 287 2nd 493. The burden upon defendant was unreasonable and unduly burdensome, and in such circumstances it was appropriate to require plaintiffs to post an adequate bond to indemnify the defendant against the costs incurred in making that production. Now, there's also, I think, a very good case that's out of the fourth. It's actually 2006. Grinnell, Grinnell, Corp v. Palms, 2100 Ocean Boulevard Limited, and it's 924 Southern 2nd 887. That's a 4th DCA 06. I actually thought this was a very interesting case. The proper preparation of a client's case demands that an attorney assemble information, sift what he considers to be the relevant from the irrelevant facts, prepare his or her legal theories, and plan his or her strategy without undue and needless interference, such as by requiring discovery of such attorney work product. Civil rule governing production of documents required only that they be produced as they are kept in the usual course of business or identified to correspond with the categories in the request, and then citing 1.350B. So that's very interesting. So be thinking about how these privileges enter into it, especially on work product, because depending on what the request is and how you answer it, there could be an invasion of the attorney's work product in the case. So I think that's a very significant issue to be aware of. And that's one of the issues, one of the types of discovery issues that you can bring up via petition for certiorari, but hopefully you can work it out with the court by doing a motion for protective order to to try to get it right on both sides. We'll be addressing other types of discovery issues at a later time. For now, any questions as usual, give us a call, and thank you again for attending Florida Appeals Journal. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.